The adoption of the resolution shows that judicial immunity will be limited by exceptional situations, such as judicial crimes. In addition, the Supreme Court ruled that the concept of crimes against humanity can also include communist crimes committed once. The concept of crimes against humanity also includes the single conduct of a judge, even related to his adjudication, constituting a communist crime, as defined in Article 2, Paragraph 1 of the cited law, if it was committed as part of an extensive and conscious persecution on account of the persecuted person's membership in a particular national, political, social, racial, or religious group, and the judge at least approved such a way of implementing the policy of the state authorities and thus took an active part in the persecution knowingly. The adoption of the resolution was made possible by the involvement of the prosecutors of the Institute of National Remembrance.
To orzeczenie Sądu Najwyższego.
This Supreme Court ruling does not automatically waive the immunity of martial law military court judges. It simply gives the court the opportunity to request the lifting of the immunity of a martial law military court judge. By the same token, this means that very transparently and in compliance with the rules of law, including on the basis of documents and evidence, any prosecutor will be able to request the lifting of a military judge's immunity. On the basis of the resolution, an analysis may be carried out of the activities and rulings of Supreme Court judges who ruled under martial law. We have them under professional responsibility, which consists of judges of a new generation who have such a fresh perspective on issues, such as the activity of judges during the martial law period. The resolution of the Professional Responsibility Chamber mainly concerns military judges. We are dealing in this ruling with the indication that the extensive and conscious persecution on the basis of the sub-judge's affiliation and to a particular national, political, social, national, or religious group caused degeneration and violation of basic principles of jurisprudence. After the collapse of the People's Republic of Poland, no settlements were made in the judiciary from the martial law period. At the time, the courts were subordinate to the communist repressive apparatus directed against the opposition. Martial law was a completely illegal and unconstitutional act. It even violated communist law. So when talking about the judges or functionaries of the system who passed sentences on Polish independence fighters, it must be said that these sentences were also completely illegal and unlawful and were not even grounded in communist law. In addition, judges appointed by the Communist State Council of the People's Republic of Poland still sit in the Supreme Court and common courts today. We are talking about Józef Iwulski, among others. Although he was suspended in 2021, he continues to take up judicial duties at the Supreme Court, as the National Council of the Judiciary pointed out in May of this year. Iwulski was a member of the jury that on December 21, 1982, imposed a 3-year sentence of absolute imprisonment on Leszek Wojnar, a solidarity activist, for printing and distributing leaflets. Józef Iwulski is a functionary of the communist regime who, under the dictates of the communist authorities, passed illegal and legal sentences on opponents of communist rule, on Polish independence fighters, knowing that he had no right to pass judgment in this way, that he was passing judgment on the basis of illegal laws. If to this day someone holds such a high position in the entire structure of the judicial hierarchy, this is a scandalous thing. But it shows exactly what we have come to by not holding the judicial apparatus accountable for this communist past, because it has never been done. The National Council of the Judiciary has repeatedly stressed that Iwulski was appointed to the Supreme Court with a significant formal defect, as he did not meet the requirement of having served as a judge for 10 years.